Welcome back to my channel. Today we're going to discuss long answer type for UPSC or KS or any state and syllabus exams that you're preparing for. And as I usually say, you should have a thorough knowledge of your syllabus and have a short notes and for every topic and subtopics, and have a proper timetable. With that you can win over this exams. Without wasting much time, let us get into today's topic. Question paper solved. Solve papers for the long answer types. It is of 250 to 150 words. I am Sumati. Let us get into today's topic. So first question is, discuss the conditions under which the parliament can make a law on subject mentioned in the state list. So the parliament has exclusive legislative jurisdictions over the subject mentioned in the union list, and the state legislatures ordinarily enjoy jurisdictions over the state list, but under the following 5 special conditions the parliament can legislate over the state list. First point is, under Article 249, this Rajya Sabha may pass the resolutions wherein it can authorize the parliament to legislative on one or more subjects mentioned in the state list on the ground of national interest, but this law will not be valid for more than 1 year, but the Rajya Sabha, by passing the same resolutions again, can extend it for another 1 year, and it may be renewed as many times necessary, but not exceeding a year at a time. So second point is, under Article 250, during the proclamations of national emergency, the parliament assumes a concurrent legislative jurisdictions over each and every subject of the state list. The state list is converted into constitutional concurrent list, and such a law, however, shall cases to have effective on the expiry of 6 months after the resolutions has ceased, and to close to operate. Point 3 is, under Article 252, the parliament has the power to legislative for 2 or more state by consent, and consent of such legislations by any other states. The article makes it possible for the parliament to make such laws relating to state subject as regards such as states holds, and legislatures empower the parliament in this behalf of resolutions. The point 3 is point 4 is Article 553 during empower the parliament to make any law for the whole or any part of the territory of India for implementing international treaties and arguments under the Article 356. During the president rule, the state government is dismissed. The state legislature is either suspended or dissolved, and the legislative power of the state legislatures should be entrusted to the parliament by the president. Our second question is, what are the essential of true federalism? Analyze the nature of the Indian federalism. Written constitution with supreme rigid, having a divisions of the Indian constitution process all the essential features of the free true federations as discussed above. The constitutional established a dual polity, and the constitution is the written and supreme. The provisions of the constitutions which are concerned with the federal cannot be altered without the consent of the majority of the states. There is a Supreme Court to arbiter the disputes that may arise between the union and state, but the Indian constitutions contains some distinctive features. India has a single constitution and single citizenship. The governor of the state is appointed by the president, and it is answerable to him. And under Article 3 of the constitutions of the parliament has been authorized to alter the boundaries of the changes the name of the state. Schedule 7 shows that the union has the jurisdictions over the more subject 97 and the most important subjects. In case of concurrent list, both the union and the states have equal legislative jurisdictions, but in case both make a law on the same subject mentioned in the concurrent list, it is the union law which provides the power to make law on the residuary list. Rests with the union. Under Article 249, 50, 250 and 252, 253 and 356, the Parliament can make a law and any subject mentioned in state list. It may be concluded that the Constitution of India is neither purely federal nor purely unitary. In the word of Professor Alexander Wicks, the Indian Federation is case of sui generis and the federations of its own type, federal constitutions with a strong unitary features. Our next question is, how is the constitutions amended? Do you think the procedure for the amendment makes the constitutions a plaything in the hands of the centers? For the purpose of amendment, the various articles of the constitutions are divided into three categories. First one is amendment by simple majority, provision of the constitutions that can be amended by the parliament by simple majority as it is required for the passage of any ordinary law. The amendments contemplate in articles 3, 5, 169 and 239A can be made by simple majority. Amendment by special majority articles is the second point, and of the constitutions which can be amended by special majority as laid down in the article 368. All constitutional amendment other than those referred above come within this category and must be affected by the majority of the total membership of each house of the parliament, as well as by majority of not less than 2/3 of the members of the house present and voting. Next is special majority and ratifications, that is third point. By special majority and ratification by states and provisions of the constitutions which requires, in addition to the majority mentioned above, ratifications by not less than half of the state legislatures, the state has been given an important voice in the amendment of these matters. The following provisions of the constitution require such as ratification by the states, and first one is elections of the president, article 54 and 55, and extent of union and the state executive powers, article 73 and 162. Union territories, article 124 to 147, 214 to 231 and 241. Next is distributions of legislative powers between the center and the state, chapter 1 and the part 6, articles 245 to 255, and any list mentions in the schedule 7, representations and the state in the parliament, article 368. An analysis of the procedure of amendment of the constitution shows that some of the provisions of constitutions can be amended by the president alone. Thus, it may not be wrong to conclude that the procedures for amendment makes the constitutions a plaything in the hands of center. Our next question, we'll discuss the next question. What is the significance of preamble to the constitution to bring out the philosophy of Indian polity as an enriched in the preamble of the constitutions? Okay, so the significance of a preamble The significance of the preamble lies in the fact that the shows that the ultimate power lies with the people of India, that it tries to establish that the Constitution of India is not an important upon the people of India by an alien power, but it has been created by the people of India themselves through their representatives, and it embodies the great purpose, objectives, and the policy underlying the provisions of the Constitution. It also contains the enacting classes, the date on which the Constitution was adopted, 26 November 1949. Every polity has a philosophy of its own, the fundamental values and the philosophy on which the Constitution is based on, the aims and objective which the founding fathers enjoy the polity to strive to achieve have been embodied in the preamble of the Constitution. The word socialist was introduced by the Constitution's 42nd Amendment, and the Amendment Act 1976. Indian brand of socialism is termed as a democratic socialism or Fabian socialism. India strives to achieve a socialistic pattern of society by democratic means, and secularism implies that India has a state recognize all the religions to coexist on the social soil of India. It means respect for diversity based on religion. India has adopted representative democracy or indirect democracy. The preamble promises justice to all citizens. Democracy cannot be established unless certain minimal rights and are assured to every member of the society. The preamble means these individual rights as the liberty of thought expressions, belief, faith and worship. The guarantee of rights to the individuals would be meaningless unless all inequities are removed from the society and each individual is assured of equality of status and opportunity. Unity among the inhabitants of this great nations was the first requisite for maintaining the independence of the country, as well as to make the democratic experiment. Fraternity, however, cannot be established unless the dignity of each of its members is maintained. The preamble states that the state in India will assure the dignity of the individuals. The Constitution seeks to achieve this objective by guaranteeing equal fundamental rights to each individuals. A number of directives have been included in Part 4 of the Constitution. The noble word of preamble represents the philosophy of our polity. No wonder that Supreme Court in Keshwananda Bharati case observed that the objectives specified in the preamble contained the basic structure of constitutions, which could not be altered even by the amendment of Constitution. Our next question is what are the major commitment of the Constitution of India as incorporated in its preamble? The preamble of Constitution as adopted by the Constituent Assembly spoke of we the people of India making the solemn resolve to constitute India into a sovereign democratic republic, securing for all its citizens justice, liberty and equality, and promoting among them all fraternity. India strives to achieve the socialistic pattern of society by democratic means. Socialism means eliminations of inequality in income and status and standards of living. The meaning sought to be given to term socialism has been that of treating all religions alike, giving respect to all religion. It means that India has a state recognize all the religions to coexist on the soil of India. The Constitution states that the state shall not discriminate on this of religion in matters of public employment and equality of status. And the Indian Constitution in its Part 3 incorporates detailed provisions for the right to freedom of religion or of individuals under Article 25 to 28. The democratic element is manifested in Article 326 of the Constitution, and which provides for universal adult franchise. The preamble promises justice to all citizens, justice as being given a superior place. The other principles of liberty, equality, and fraternity. A democracy cannot be established unless certain minimal rights are assured to every member of the society. The preamble mentions these individuals' rights as the liberty of thought, expressions, belief, faith, and worship, and these are guaranteed against all the authorities of the state by Part 3 of the Constitutions. The guarantee of the rights, Article 19 to 25-28, to the individuals would be meaningless unless all the inequalities are removed from the inhabitants of this great nations. Was the first requisite for maintaining the independence of the country as well as to make the democratic experiment. Thus the preamble embodies in Solomon from all the ideals and the aspirations for which the country had struggled during the British regime. It explains the fundamentals underlying the structure of constitution. Next question would be, the creation of smaller states is need of the or comment. Under the parliament system of government, the formulations of policies, the responsibilities of the political leaderships with the assistance of senior civil servants, while the implementation is mainly the responsibilities of the bureaucrats at the field level. Senior officers are expected to maintain a close watch on programs implementations through field visits. But in the case of states with very large populations, this important responsibility is not adequately attended to. Therefore, it is being felt that reducing the size of the state has been an absolute necessity if the people are to get full benefits of the development programs. Out of the 28 states in the Indian Union, 10 have a populations above 50 million, and the 5, namely out of 28 in the Indian national, 10 have a populations above 50 millions, and 5, namely Andhra Pradesh, Bihar, Maharashtra, West Bengal, Uttar Pradesh, and have populations of 75 million each. The demand for the divisions of state has arisen most forcefully from the people of this state, as they have been experiencing the disadvantages of having a large size of populations. Uttar Pradesh, with the populations of nearly 166 million, is a chronic case of underdevelopment. The need for its division is obvious. In the past, some senior politicians had resisted the idea of carving a smaller state out of UP, as they feared that such a steps would reduce its importance in the national politics. But now most political parties are in favor of carving their 3 or 4 new states out of UP. Now it's notwithstanding the creation of Uttarakhand, in the ultimate analysis, it's if a separate a state is what the overwhelming majority of the populations of regions wish to have a ground of better administrative convenience and efficiency. Considering such a demand will be in keeping with the spirit of Article 3 of the Constitution and with the principle of democracy. So our next question is, what is the constitutional position of the directive principles of the state policy, how it has been interrupted by the judiciary after the emergency in 1975 to 77. The constitutional position of the directive principle has been mentioned in Article 37, which states that the provisions contained in Part 4 shall not be enforced by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making law. The Supreme Court in Minerva Mill Limited case 1980s viewed that Part 3 and the Part 4 of the Constitution are complementary and supplementary to each other. The court observed that the Constitution was founded on on the bedrock of balance between the fundamental rights and the directive principles. To give absolutely primacy to one over the other was to disrupt the harmony of the constitution, which the court held was an essential feature of the basic structure of the constitution. In the Rajan Tiwari versus Union of Indian case 1983, the Supreme Court held that both the fundamental rights and the directive principles aims at the same goal of bringing about social revolutions and the establishment of the welfare state. It is mandate of the about social revolutions and the establishment of welfare state is mandate to the constitution, not to legislative and the executive only, but to the court as well. And Air Indian Statutory Corporation versus United Labour Union 1993, the Supreme Court observed that these directives are the force runners of the Union Conventions of the Right to Development, and these principles are embedded as an integral part of our Constitution, and these now stand elevated to the inalienable fundamental human rights. So, our next questions would be: what is the constitutional position of directive principles of state policy, how it has been interrupted by the judiciary after the emergency of 1975 to 1977? The constitution, our next, this we have already solved, I guess. Our eighth question is: analyze the role of the president in a situation of hung parliament. In a hung parliament, how the president situation is what we are going to discuss. The constitution states that the parliament ministry shall appointed by the president, according to article 75. In case of hung parliament, the president has to make an informed judge to invite a leader of party, which either by him itself or with the declared support of other parties will secure the confidence of Lok Sabha. In such a situation, the president would have to invite person who seems to be able to form a government with a reasonable prospect of maintaining government in office. The Indian innovations in constitutional law is the president directs the government to seek a vote of confidence at the earliest. The former President of India, R. Venkata Ramanan, proposed a simplistic rule of invitations in the order of strength of the political parties in hung parliament. He maintained that calling parties in the order of their strength in the House will be the most prudent and non-controversial course of actions. President Venkata Ramana claimed to have applied this rule twice in 1989 when he called on VP Singh, and in 1991 when he called on Narasimha Rao to inform the government, but the unreliability of Venkata Ramanan's views was shown when President S.T. Sharma invited A.B. Vajpayee as PM in 1996, simply because he was leader of the BJP, which was the single largest party with its allies in the 11th Lok Sabha. Within 13 days of the formation of government, Vajpayee had to withdraw his motions of confidence in the Lok Sabha when defeat stared him in the face. The 1998 results again presented a hung parliament. This time BJP President K.R. Narayanan carried out the careful exercise of them explaining that the BJP, with the support of the parties, would be able to secure the confidence of the House. The 14th Lok Sabha elections, again President hung parliament, considering the assured support to the Congress. President APJ Abdul Kalam invited Sonia Gandhi of the Congress to form the government. This time he did not direct the PM to seek vote of confidence, as the government was assured a majority support. Thus, in every case of hung parliament except in 1996, the president's invitations to form government has been made up after consultations assured that the largest party or political formation supporting the largest party would command majority support in parliament for the reasonable period of time. Our next question is Parliament in contemporary times has declined. Do you agree with the statement? Give reasons in support of your answers. There is an overwhelming consensus in the academia and in civil society fora on what is called decline of Parliament. Our founding father adopted for the use as a system of representative parliamentary democracy, but if the representative of the people themselves lose the faith of people, there is every cause for serious concern. An overview of development in parliamentary invitations since the first Lok Sabha reveals some very interesting and some disturbing facts. The number of days on which the Houses of Parliament sit each year and the time that it devote to transacting business has come down considerably in recent years. Indeed, in 2008 marked the nadir of Parliament, quite aside the strange spectacle of the monsoon sessions being continued at the height of winter. The number of sittings touched a record low of 46. There has been in recent years quite some thinking about devolutions of parliamentary authority, deteriorations in the equality of members, poor level of participations, and the like. Today, one notices a certain cynicism towards the parliamentary institutions and the normal parliamentary process and the parliamentary reason. We have an unending debates in regards to the falling and standard in the conduct of legislators, as evidenced by poor quality of debates and niggardly and the attendance in the legislative, unruly behavior of members, since sense of pandemia, disruptions and adjourn name calling, disregarding president offense, and tearing of the agenda. Role of money and muscles powers in politics are the most common topics of popular discussions today. The parliament in the future would be relevant only as a dynamic institution, ever adjusting its functions and procedures to the changing needs of the times. If democracy and the freedom ought to endure, if representative institutions ought to be made impregnable, it is essential to restore to Parliament and its members their traditional esteem and honor in affections of the people. Our next and last final question is briefly mention why and how the chapter directive principles of state policy gained the precedence over the chapter on fundamental rights in the Indian constitutions. It was in 1971 that first step was taken to provide the supremacy for the directive principle in forms of Article 31C, and which was added to the constitutions by the Constitution's 25th Amendment Act of 1971. The effect of the insertions of Article 31C was to provide supremacy to directive principles contained in the Article 39B and 39C over fundamental rights contained in Article 14, 19 and 31. It enhanced the utility of the directive principle, which had stood the testimony of the Supreme Court in Keshwananda Badri case 1973. The court observed in building up a just social order, it is sometimes imperative that the fundamental rights should be subordinated to directive principles. Economic goals have an uncontestable claim for priority over ideological ones on the ground that excellence comes only after existence. It is only if men exist that there can be fundamental right. To further widen the scope of directive principles, the Constitution's 42nd Amendment Act 1976 amended Article 31C for providing supremacy for all the directive principles. The effects of an amendment was to give overriding effect to the directive principles and to make them immune from being declared as violative of the rights guaranteed by Articles and 14, 1931. However, the change incorporated by the 42nd Amendment Act was struck down by the Supreme Court in Minerva Mill case 1980. The court thus restored Article 31C to its original status as inserted by the 25th Amendment Act of 1971. It thus follows that directive principle contains in Article 39B and 39C shall have a primacy over the fundamental rights contained in the Article 14 and 15. That's all for the day, friends. Do like my videos and subscribe my channel, and keep learning. Have a habit of writing every answer that you practice. Have a